Welcome to this installment of Clarifying Tax Situations with attorney and CPA David W. Klossing.
How much risk exists for prosecution of tax crimes in a divorce scenario? Here's the bottom line in this area. If persuasive evidence of tax fraud comes to the attention of a judge presiding over divorce, the judge's staff, the judge, a member of their staff, or someone in the gallery who witnesses the admission of tax fraud, can report the existence of the tax fraud to either the IRS or a state taxing authority. Therein lies the real risk. The bottom line in this area is that IRS agents are trained to scrutinize the public divorce court documents for evidence of underreported income or tax fraud. If one of the parties to a divorce, an innocent spouse most likely, or less likely, both spouses have their hands dirty in the tax fraud, but all it takes is one of them to demand that a settlement be based on actual income that was earned, not the income that was reported to the government. If this happens, the risk of criminal tax fraud prosecution goes through the roof. Both the client in this scenario and divorce counsel need to clearly understand the risk of a criminal tax investigation ensuing at a later date because of this fact. It's also important to remember that a divorcing spouse can, on their own accord, tip the IRS about the spouse's previous tax fraud. This can be done simply out of a desire for revenge or out of pure vindictiveness. The tipping spouse may even be eligible for a whistleblower award. It's also important to remember that if a client's intentional failure, or worse yet, fraud, in disclosing financial resources to a divorce court is later on discovered, it is extremely difficult, if not outright impossible, for that client to recover the almost assured loss of credibility that will take place with that divorce court. Once more, there's exposure for potential perjury charges. If false, misleading, or incomplete financial evidence is submitted, followed by either the divorce court making a consequently faulty judgment or the parties themselves negotiating a faulty settlement agreement, then the divorce is always subject to being reopened at some point in the future when the misstatements are discovered and retried at great additional expense and at potentially a great disadvantage to the non-disclosing spouse. As I've stated earlier in this slide series, the commonly charged crimes in divorce are tax evasion, willful failure to collect and pay taxes, or filing false returns or false documents. You can find the definitions of each of these tax crimes on my website.